Appeals, First Appellate District of Ohio, with the Honorable Candace Krause presiding, is now in session. Please be seated.
Good morning, everyone. Welcome to the First District Court of Appeals. We have two cases up for argument today, and my understanding is that the parties informed the court that you wanted to change the order, and so we're happy to do that for you. The first case set to argue is State v. Hall, and for appellant, I see we have Ms. Nelson. Okay. And then for the appellee, State of Ohio, we have John Boat and Mr. Wessels.
Yes.
Good morning. The second case to be argued is State v. Yoder, and for appellant, Angela Glazer.
Angela Glazer, ready to proceed.
Good morning. And then for the State of Ohio.
Good morning, Scott Heaney. I filed a substitution this morning.
Great, good to see you. All right, so for the Hall case, Mr. Vogt and Mr. Wessels, you're going to split the argument into the two issues.
That's correct, Your Honor. It's our intention to have, I'm going to handle the first assignment of error, reasonable particular suspicion. Mr. Wessels will handle the second assignment of error.
Okay.
So if court permission, I'd like to go first and reserve 7.5 minutes for Mr. Wessels.
Okay, I'll try to let you know how much time you have left. And Ms. Nelson, do you want to reserve any time for rebuttal? 3 minutes?
Yes.
If she stands up.
Oh, okay, sure, that's fine. Okay, we're ready when you are.
Thank you. Good morning, Your Honors, and may it please the Court, and good morning, opposing counsel. Sarah Nelson, again, on behalf of the appellant, Desmond Hall. I'm going to begin this morning going in order of the assignments of error, and start by asking this Court to reverse the trial court's decision denying Mr. Hall's motion to suppress, because Cincinnati police did not have reasonable suspicion to support a pat-down search of Mr. Hall. The state argues in this case that Officer Del Razo was justified in conducting an investigative stop and frisk of Mr. Hall, but this claim is unsupported by the facts of this case and by this court's precedent. And there are 3 points I'd like to focus on in support of my argument this morning. The first is Terry's particularized suspicion requirement. That is person-specific, and what's missing in this case. There's no particularized suspicion as it relates to Mr. Hall being involved in any criminal activity or potentially armed and dangerous. To quote this court's decision in State v. Henson, or I should say to paraphrase quotes from paragraphs 31 and 32, an individual's presence in a high crime area by itself is insufficient to justify the stop and frisk of a person, especially when the offender did nothing to make the officer worry that the offender would cause him harm. And the need to act out of concern for officer safety does not legitimize the indiscriminate stop and frisk of the first person observed on the scene. I pull out those 2 quotes because that's essentially what we have in this case. Officer arrived on scene due to hearing shots fired in a nearby area. He responds to the area where he thinks that they're coming from, and he stops Mr. Hall or he approaches Mr. Hall and another man because they're the first people he sees.
Was this consensual at that point?
Yes, I would
Okay.
agree that it was consensual, and I will return to that point because it is important.
And counsel, the police officer was going to the location where he had heard the gunshots, correct?
That's correct.
And those 2 individuals were standing in that location where he had heard the gunshots, is that right?
They were standing in the apartment complex vicinity, which is where he believed the shots were coming from, was the apartment complex.
Well, it wasn't just a complex, was it? Didn't he drive into the parking lot and proceed to that exact location? And in fact, another individual appointed the officer to confirm that that was the direction that the shots were coming from?
I believe that is a correct interpretation of his testimony, but I would still stand by that this is a large apartment complex. I believe there's over 30 units, and it's just the officer's observation of the shots fired. So to the extent that he hears them coming from the general vicinity of an apartment complex, it's hard to discern exactly where they come from.
But, I'm sorry, didn't the officer specifically say that he thought the shots were coming from a specific location within that complex? I think the west of Martin Luther King?
He did approach the apartment complex based on where he thought they were coming from. But I guess what I'm pushing back on is this specificity, because it is a large apartment complex and there were multiple people in the vicinity. And yes, your comment about somebody pointing in a certain direction is also supported by the facts of this case, but my client and the person he was with also directed the officer to another part of the complex. So there's facts all around that the shots came from possibly that apartment complex, but not necessarily specifically where my client was standing. That's where he was drawn to in the first instance, yes.
Okay, thank you.
But even then, we're at this consensual encounter point where he's approaching them to ask questions. And that's certainly allowed because he's investigating shots fired. But what's missing is my client giving any sort of indication that he is armed and presently dangerous, which brings us to this fact of observing a suspicious bulge on the person that he was with. And that's important because it wasn't a suspicious bulge on my client, but the person he was with. That doesn't make my client particularly armed and dangerous, but perhaps the person he was with.
So let me just try to understand, just so you can explain the law to me. This was a consensual encounter initially. And in the midst of a consensual encounter, if the officer are you saying that if the officer believes that somebody's armed and dangerous, they can do a pat down?
Yes.
Okay.
If facts arise that give the officer additional facts to support suspicion of being armed and dangerous, then that would support the pat down for officer safety.
The officer doesn't have to have a suspicion that he committed a crime necessarily, only that he might be armed and dangerous?
Armed and presently dangerous, I believe,
Okay.
is the language from Terry. And I would draw this court's attention to State v. O'Neill, which deals with this question of the observation of a bulge or a firearm on a particular person, because it doesn't necessarily lead to suspicion of criminal activity in light of the transition from needing a permit, which is what O'Neill dealt with, suspicion of criminal activity when people needed to have permits to carry a concealed weapon versus today where, in the facts, the position my client was in and his counterpart, there's no permit required. So the fact that there is a bulge, someone's carrying a concealed weapon, isn't necessarily indicative of criminal activity or maybe even armed and presently dangerous. I mean, obviously, suspicion of being armed, but the dangerousness component is still lacking. But again, it's not really relevant because it relates to the other person.
What if the officer believed that, that your client was somehow involved in these gunshots? Would he then be able to pat him down?
There would need to be facts that would make that suspicion reasonable, and I don't believe that there are in this case.
Okay.
The observation of fire,
Didn't your client say that he did own a gun?
and that was in the apartment, was his indication to the officer.
So in that universe of apartments, we know that your client had a weapon. And the officer knew this before he did the pat down.
Correct. But the ownership of a firearm doesn't necessarily make a person, one, armed presently, and two, dangerous. Gun ownership is widely accepted in this country, in Ohio now, given that people can carry it without a permit.
Counsel, can I go back to the specificity issue?
Yeah.
If the officer was sure that the gunshots were coming from the exact location where your client was standing, would that give the officer sufficient suspicion or concern about him being armed and dangerous?
I don't think that there is enough particularized suspicion related to my client, even if they are standing directly where the officer thinks the shots are coming from, because he's not engaged in any sort of evasive behavior. He doesn't appear to have a firearm on his person like his friend, I'll call him a friend, the other man that was with him. He's not nervous, erratic, trying to flee the scene. He's engaging with the officer in a consensual encounter, and by all intents and purposes, he's complying with the investigation.
But the Terry stop is to protect the officer, correct?
Terry, there is an officer safety component, but that can't carry the day. There has to be particularized suspicion related to the person sought to be searched and frisked.
And if someone's standing where the officer thought gunshots were coming from, would the officer be justified in being concerned for his personal safety approaching that individual?
I disagree. Based on a combination of cases, Harrison and Henson. Harrison is a Ohio Supreme Court case where officers responded to the personal observation of gunshots. They responded within 30 to 60 seconds and approached the sole person on the scene in the area where they thought exactly the shots came from. That was upheld as a reasonable Terry stop and frisk because of the defendant's behaviors and his admission in that moment to hearing the shots fired and also admitting to have a firearm on his person. Contrast that with Henson, which this court found a Terry frisk was unjustified because a person was found in the vicinity of where the gunshots were, but the person specifically wasn't engaged in any behavior to alert the officer's suspicion to potentially armed and dangerous or involved in the criminal activity that drew the officers to that area. So we're kind of, my client, I think, is more analogous to the defendant in Henson, even though I acknowledge that the facts are more similar to Harrison in terms of the personal observation of the sound of gunfire. But when you approach somebody and they're not behaving in any way that is indicative of being armed and presently dangerous or in the course of criminal activity, officer safety concerns and the sound of gunfire is not enough to stop anybody at the scene.
So when did this consensual encounter become subject to this Terry analysis?
When the officer reached in to do the pat-down, which is
Okay.
similar to Henson.
So when the officer grabbed his arm, I guess, or?
So he reaches in to do the pat-down, which is similar to Henson. Officer reaches in. Mr. Henson and my client, Mr. Hall, both turned their bodies away from the officer or reacted in a way where they did not want to be touched. My client says that he did not want to be touched. That's important because he's allowed to terminate the encounter with the police the entire time that it is a consensual encounter, which is what Henson stands for. You're not allowed, officer can't intrude upon your personal space, even when you blade or try and avoid the officer's contact, because that's still within your right in the consensual encounter to terminate. And it doesn't, that movement doesn't turn the consensual encounter into a justifiable frisk, which is what exactly happened in this case. The officer used the turning of the body away to disengage or to avoid the contact and said, well, now, why are you turning away if you have nothing to hide? That's not the focus. My client still had his right to be free from the police intrusion up until that point, and then the officer intruded on his personal space, invaded his privacy to conduct the pat-down. It's that point that we think the conduct that followed was illegal. The frisk, the admissions to having a gun on his person, the ultimate discovery of that firearm, all should have been suppressed.
And at the time so you said when he reached to pat him down is when the Terry analysis comes into play. Are we looking at that point in time of whether the officer had a particularized belief that your client had done something criminal?
Yes, or was presently armed and dangerous. Is he acting in a way that puts the officer in a position where he feels that he's a heightened risk for officer safety concern?
Okay, and why is it not logical that if his friend has a firearm located on him, that your client might also have a firearm? Why is that not reasonable?
The case law suggests that there needs to be some observation related to my client, and typically that's, we see a bulge, we see something in your pocket, we see something specific to this person, which is what's missing in this case. So just being in the general vicinity around people who are otherwise seemingly armed and presently dangerous doesn't make Mr. Hall presently dangerous. There needs to be something more specific to him. It can't just come from his associates. I believe the case law supports that.
What were the behaviors in the Harrison case that were different?
The defendant that was stopped, Mr. Harrison, was alone. I believe there were some nervous behaviors, but more importantly, when police approached him, he admitted to hearing the gunshots and admitted to having a firearm in his person. So then the police
So
engaged
in this
him.
case, your client admitted to hearing the gunshots, and the person immediately next to him had a bulge that was apparent. And then the officer said that the officer was going to walk across the parking lot or something like that in order to further their investigation. And it seems to me that at that point, he was primarily concerned with his own safety because he didn't want to turn his back on those two people.
I still submit that there's no reasonable suspicion related to my client. He did not admit to having a firearm on his person like the defendant in Harrison, which makes my client more similarly situated to the defendant in Henson from this court's decision. The officer could certainly engage in a pat-down of the person he thought was carrying a firearm, but that doesn't leap to say that my client is equally armed and presently dangerous. To hold otherwise would suggest that police can stop and frisk anybody in the vicinity of a high-crime area where gunshots were recently heard. And between Henson and Harrison, I don't think either case supports that specific position. And there's nothing specific to my client to suggest that he is presently armed and dangerous, despite the fact that he's in a high-crime area. Acknowledged hearing gunshots, points in a different direction, doesn't know where they're coming from. And again, his associate is the one who appears to be handling the firearm.
Ms. Nelson, so we took a lot of your time
Yeah,
on the
that's fine.
first issue. And I had a feeling this was going to happen. What I'm going to do is I'm going to give each side an additional 5 minutes. Okay, to talk, because I would like you to talk about the second assignment of error. So you're at 13 minutes. I'm going to give you another 5. So if you want three for rebuttal, you got another 4 minutes to talk about the second assignment of error, which will leave you your 3 minutes for rebuttal, and I'll give the other side 20 minutes. Sound
Certainly.
good?
Yep, that sounds great.
Okay.
So just jumping right into it, I think I'd be remiss to not talk about the Rule 9E motion that was filed recently in this case, because it has two components that are relevant. It's the introduction of the recent precedent from this court, State v. Brown, and then this fact that was buried in the, what I'll call the triggering case, the pending criminal complaint for negligent misdemeanor assault. That case launched the accusation for the CCW offense, because if somebody who is pending misdemeanor negligent assault can't concealed carry. I think that this case can be decided based on the record that was before the court, both the trial court and this court, and it would be against the principles of Rule 9E to factor in the bond condition that the state is trying to supplement the record with, because it wasn't a fact argued below. The state in their motion at the trial court level said there were no other factors that it was aware of to preclude my client from having a firearm, and that is how the argument was phrased, and that was the posture of the argument before the trial court. The trial court also rested its decision on a Bruin-specific analysis, because Rahimi hadn't come out yet. Obviously, this court's recent precedent was not before the court below. So on the historical analysis alone, reversal is warranted. This case is similarly situated to the defendant in Brown, which was a pending felony indictment. This is a pending misdemeanor complaint.
But this is different, right? Is this different? I thought was Brown not a complete prohibition?
Brown,
Of carrying a firearm?
a felony, yeah, disability. Oh,
Okay.
so
So
you're getting
this-
at the comparison?
Yeah, because that's what we have here. I mean, your client could openly carry a firearm, right?
If we accept the universe of facts that was before the trial court, yes. Yeah.
Okay, so this is very different than Thacker. This is very different than a complete prohibition. This is a concealed carry prohibition only, not a complete prohibition, right?
I respect that distinction, yes, that's correct.
Okay, and, looking back at like Bruin and Heller, I mean, they go through all of these concealed carry bans from the 1800s. And so wouldn't that be a historical analogy to say that concealed carry bans are okay as long as open carry is available?
The concealed carry limitation, it is still dispossessing my client in a way. It's restricting the manner in which he's allowed to carry a firearm, which is still at play despite
Right.
Helen and Bruin.
But aren't there historical analogs that demonstrate that the state can restrict concealed carry?
I think what I recall from the Heller and Bruin discussion is that they didn't necessarily say that concealed carry was still lawful across the board. We still needed to scrutinize the history of these laws. To your point, is there still historical precedent that says that these laws were in existence at the time? I would just submit that the historical analysis in Brown seems to suggest that there is a question presented with respect to taking away firearms based on the nature of a pending charge. And, that's still true. We're still restricting his right to carry a firearm. The question is whether or not that right is constitutionally allowed because he's still able to open carry would be for this court to interpret, but the case law history seems to suggest that the fact of a misdemeanor complaint alone, just like a felony indictment alone, shouldn't trigger disarmament. And
You're at 4 minutes.
Okay.
If you want to reserve 3, unless my colleagues have additional questions. Okay.
okay, just to make one final point on this assignment of error. One, the first assignment of error is dispositive, so we don't even need to get to the second if this court doesn't need to. But lastly, there is, I think, an opportunity to remand this case for reconsideration in light of Brown and Rahimi because it was not considered below. And with that, I will yield my time. Thank you.
Thank you.
So you'll have 10 minutes, I guess, split it up evenly, 10 minutes.
Yes, that sounds good, Your Honor, thank
I mean,
you.
however you want to do it, you have 20 minutes.
Well, how about I'll take 12?
Okay.
Is
You
that
can do it
okay?
however you want.
12. Objection, okay. So, yeah, we'll do 10 and 10 and take it from there. Well, Judge Kraus, Your Honors, opposing counsel, may it please the court. Officer Del Rasso's stop of Mr. Hall was supported by reasonable, articulable suspicion justifying the search. So I'd like to just focus on a few of the key points in this case that I think, based on the totality of the circumstances, support the constitutionality of this search. First off,
Can you, though, before you get to the reasonable articulable suspicion, tell me when this went from consensual into, and when we're starting our Terry analysis?
I agree with Ms. Nelson, Your Honor, when Officer Del Rasso goes to pull Mr. Hall's arm for the purposes of the pat-down.
Okay.
But, so, first off, we have Officer Del Rasso. He hears gunshots, so already I think that's pretty strong in his favor. This isn't a case of the police responding to a report of gunshots. He hears gunshots at the Clifton Colony Apartments on MLK Drive, a location that Officer Del Rasso said he responds to at least once a week for gunshot reports. And to your question, Judge Moore, there was a specific location in this apartment complex of multiple buildings that he went to that he thought the shots came from. And on the way to that location, bystanders basically confirm it's up there. Where you're going, officer, where Officer Del Rasso thought he was going was the correct location. That's where the bystanders point him to as well. So he arrived to that location within 2 minutes of hearing the gunshots, and that's where he, of course, observed Mr. Hall and the other unnamed individual. So we have just two people there. There are two people at that location that he responds to. So they do have a brief conversation, and to your question, Judge Nestor, Mr. Hall says he has a gun, but it's inside.
Counsel, can I ask a question? Before they have that brief conversation, could the officer have had performed the Terry frisk at that point? Could he have walked up to those two individuals and done the pat-down?
I think so, Judge Moore. I think, when we talk about specific facts based on the totality of the circumstances, I mean, we have a specific location that Officer Del Rasso thinks gunshots are coming from, and then we have bystanders pointing him to that specific location. I think that is justifiable for Officer Del Rasso to search those individuals, maybe not for a protective search, but reasonable articulable suspicion that they were involved in discharging firearms, which is against the law.
Why not a protected search?
I think there requires maybe some more suspicious movements or other justifications for that part for officer safety, but I think you definitely see that in this case. And I think the key point for the court to consider is that Mr. Hall and the individual he was with say, oh, it happened somewhere else in the apartment complex. So Officer Del Rasso knows initially that, okay, I think it's coming from right here. I have two individuals coming from right here, and these guys are saying, oh, no, it happened somewhere else. So I think it's reasonable for Officer Del Rasso in that position to suspect that these individuals are being less than truthful. So, Judge Moore, so when he notices the bulge, I think that's another elevating factor in this case.
But standing in that exact location where he thought the gunshots were coming from is not enough to trigger concerns for officer safety.
Not sure, Your Honor. I think definitely for the facts of this case, the fact that we have Mr. Hall and this individual being potentially dishonest, and especially the bulge, and the key part about Mr. Hall being dishonest as well, so if he said he had a gun and he was inside, or the gun was inside, and Officer Del Rasso said notices him being dishonest about where these gunshots happened, I think it's reasonable for Officer Del Raso to infer that Mr. Hall is also potentially being dishonest about having a gun on his person.
Now, I thought that, were they dishonest about where the gunshots happened, or did they say that the person that shot the gun ran?
I think it's both, Your Honor. Yeah, that's another detail as well. They said.
Did the officer express that in his testimony, that he thought that the defendant was not telling the truth?
I don't believe so, Your Honor, but I think in the totality of the circumstances, I don't think they got into it with that specificity, but I think considering the totality of the circumstances, I think it's fair for Officer Del Raso to have assumed that. But even if.
But just so I understand your point, so gunshots come from a certain area, the officer believes the gunshots came from a certain area, he comes into contact with some individuals. There's two people here. You're saying that immediately he could search these people for suspicion that they were involved in the gunshots? Is that what you're saying?
Yes.
Okay, what if there was like 10 people?
So, yeah, I think that's a good point, Your Honor. I think, I agree with Ms. Nelson. I think the law is very, very clear. We're not saying that officers can indiscriminately search, people at a location. I think maybe there's a number where there's enough people at a location where it becomes more difficult.
Well, Hairston was one person. Are you saying that now we can make it more than one person?
I think it depends on the facts and circumstances of each case, and I agree with you, Hairston was one person, but I think the reason that this is stronger than Hairston is that we also have the bystanders directing Officer Del Raso to the specific location. I think the location was less specific in Hairston. I think that weighs in our favor in this case.
Okay. But you think that there is a limit of the number of people that could ultimately be stopped and frisked who are in the area of gunfire?
Probably, yes.
But the two people here is not the limit?
No,
Okay,
that's not before the court today.
okay.
So this case, I think, kind of is similar to Hairston. Officer Del Raso arrived within 2 minutes. The officers in Hairston arrived within 30 seconds. I think Hairston applies to this case, and they were both supported by reasonable articulable suspicion for both possible discharge of a firearm and officer safety based on dishonesty and the bulge. And the other.
So what is the crime that he was reasonably suspicious that Hall was engaged in? The gunshots, or is there a different, some other crime?
I think carrying concealed weapons potentially and gunshots as well.
Okay.
So
And is that still a relevant thing in light of the fact that most people can carry conceal? I mean, is there a difference in how we analyze these cases now that concealed carry is pretty, you don't really need a license and most people can carry conceal?
Sure, I think it's, that's all true, Your Honor, but I think it's relevant in light of the fact that Mr. Hall claimed he did have a gun, but that it was inside, but also that the shots happened somewhere else that they couldn't have happened in this case.
Okay.
So again, Your Honors, based on the totality of the circumstances, Officer Del Raso had reasonable suspicion to search Mr. Hall and also frisk him for his safety based on gunshots occurring at a specific location that was confirmed by bystanders, and then Mr. Hall and his associate lying. I mean, it's a lie. He lied. That's in the record about having a firearm, and he said it was inside. He lied about that. It was on his person, and then the
Well, you
bulge.
found that out, he already, that's after the fact.
I know,
right? Okay,
yes.
so that's not what leads to a reasonable
No.
suspicion. You're saying he lied about where the gunshots came from?
That's right,
Okay.
yes. So unless there's any other questions about the RAS for the Terry stop, I'll reserve the rest of my time for Mr. Wessels. Thank you very much.
Thank you.
Thank you, and may it please the court. I wanted to, unless there's any particular questions that the court has off the bat, I wanted to make a distinction specifically as it related to the 9E motion that the state filed. In this case, there is both a facial and an as-applied challenge on this matter. As this court is aware, the Brown decision dealt with an as-applied challenge to the particular facts of that circumstances. I think the state's position would be if this court believes that an examination of the bond conditions for the underlying charge is relevant and is, or I guess as necessary for this court to make a determination as to the as-applied challenge. Our request would not be to reverse the decision and send it back, not be to reverse the decision, but to remand it back so that the state can have the opportunity to develop the record specifically in consideration of Rahimi and Brown, neither of which were the law at the time that the decision in this case was decided. That is, if the court believes that it would not grant the state's motion. Essentially, we have here a fact that this court considered. We would have liked the opportunity to put that into the record below. And frankly, I do think that the court did make considerations about the underlying case, but obviously it didn't appear necessarily in the record.
Do you think a remand is necessary anyway?
I don't.
Pursuant to Rahimi? Because I know we do have a judge on this court that believes that because Rahimi wasn't out for a lot of these cases, there should be a remand, but what is the state's position?
I guess
What would you do differently?
I don't believe that a remand is necessary facially or as applied for this particular type of challenge, because I do not think, as the court sort of pointed out earlier, that this is a charge that is dealing necessarily with a specific ban. It's dealing with manner-based prohibition, which I think the Bruin decision would indicate has a long-standing tradition in the nation's history. At least as it goes to the as-applied challenge, I think that the state has met its burden in both facially and as applied on the record that's currently before the court. So I don't believe that a remand is necessary in either scenario. But I guess my point would be, if the court feels that that is a fact that would have been relevant to the as-applied challenge, our ask would be not to reverse, not to decide it, but to remand it back for that consideration. And more to the point that I was making specifically about the nation's traditions around firearm regulation, I think the Bruin decision puts pretty clearly that objective standards used to limit someone's ability to possess a concealed weapon does fall within our nation's history. Specifically, the use of objective standards is something that the U.S. Supreme Court has pointed out as something that would fall in line with the constitutional regulation of firearms.
So do you think it would be constitutional for the state of Ohio, as long as everybody could still open carry, for the state of Ohio to ban everyone from concealed carry?
I do.
Okay.
I think that as I read Bruin anyway, the suggestion, at least as their interpretation of concealed carry, the Bruin case specifically dealt with concealed carry in the state of New York, which was defined by subjective standards. So the only way in New York that you can carry a firearm in public was if you had a concealed carry license, and they used subjective standards in order to limit that. My reading of the history as analyzed in Bruin would suggest that they came to the conclusion that, yes, there is some historical tradition of regulating concealed carry. The caveat for them was that those regulations were only constitutional so long as there was an option for open carrying that existed at the founding. So in extrapolating that, they, as I read Bruin, interpreted New York's law and said that it went too far because the standards that they found for regulating concealed carry were objective, and in New York's case, they were subjective. They were up to, I think you had to demonstrate like a specific need for concealed carry before you could be granted a license. And their reference in Bruin was, I guess, some of the guidance, at least that appears in Justice Kavanaugh's concurring opinion, would suggest to the states that for those where New York is a may-issue state, for those shall-issue states like Ohio, which automatically grants a concealed carry license, so long as they're employing objective standards, that would be fine. Notwithstanding that opinion that the state of Ohio could completely ban concealed carry constitutionally, I think that the limitations that we have put on concealed carry also have a historical analog. So we're even going one step further and saying, I think as this court has already somewhat accepted in Brown, that there is a historical tradition of regulating firearm based upon a charge that is pending.
Isn't it more of a policy consideration? I think you made that argument in your brief, to carve out certain people that can't conceal carry.
Right. I think
Rather than a Second Amendment problem.
I guess, yes, if the decision of which groups are, I guess, and we would submit are too dangerous to possess a firearm or there is a matter of public policy concern. That would be the,
And it would be more of, subject to like an equal protection challenge, I believe I asked you both the last time you were here.
and I think I'll repeat what I believe my answer was last time, which is the law is very unclear in this area. As I see it, yes, it is more of an equal protection clause. Although with the way that I read Bruin, I think it's difficult to determine how we handle those types of equal protection clauses when they're dealing with the Second Amendment going forward. So I don't have a clear answer about the state of what the law should be. At least what I can say about this challenge, though, is that as far as the Second Amendment is concerned, there is a longstanding historical tradition of regulating concealed carry. There is a longstanding historical tradition of regulating firearm possession by those who are accused of violent or dangerous crimes, or as this court has put it, crimes against the person, which I would submit that negligent assault falls under. And so I do think that the application of those laws, either facially or as applied to the defendant in this case, are constitutional. I think the state has met its burden as to that aspect.
So ironically, the defendant in this case could open carry,
He could.
and in that circumstance, the police would have reasonable suspicion to stop him and inquire and pat him down in regard to other weapons too.
If he were to be open carrying and were to use that as a, I guess if the thought process of the officer is if he's open carrying one firearm, he might have another firearm concealed on him. Is that what you're saying?
Well, they've just heard shots fired. He's, he could,
Right,
it
if
seems
he-
to undermine the public policy rationale where the safety, it doesn't seem like safety is heightened by the idea of public carry or open carry.
That may be true. Obviously, there are more stringent Second Amendment problems tied in to the interplay between the public policy and the individual constitutional rights of the person who's carrying. At least as I understand our concealed carry laws, with specific result to negligent assault. Negligent assault is not listed, is not defined in Ohio Code as an offense of violence. It is it is one of the specific crimes that is carved out in our concealed carry law that limits your ability to conceal carry. And I think the reason for that being is it involves physical harm to another individual with a firearm specifically. So that would be my understanding of the public policy aspect of it, at least for negligent assault, is that if someone is alleged to have been specifically dangerous with a firearm, although the only allegation is negligence, not necessarily that they purposefully have done it, there is still some reason to imagine that they should not have a firearm concealed upon their person. But it's correct to say that a negligent assault, either conviction or a complaint, does not prevent you from open carrying.
So if he was openly carrying a firearm, the police officer coming up on him in an area where he had heard gunshots, the fact that he was openly carrying would not generate any kind of reasonable suspicion because that's perfectly legal. Is that correct?
No, not. I would think that if there were, what I should say, if the officer were investigating a crime and believed that there were a crime to have happened in a specific area and there were gunshots that took place, I think an officer, it depends on the specific circumstances, but could develop reasonable suspicion that that crime, for example, firing over an open roadway, if they were investigating that specific crime and saw someone open carrying, you can open carry. You still can't fire a firearm over a public roadway. I believe that they could develop reasonable suspicion based on the fact that they were open carrying in combination with that other fact, if that makes sense. I will say as well, for consideration as to the as-applied challenge, there is the possibility as well to apply for relief from, even though for not a weapons under disability, but application for relief, which is something you can do when you have a pending indictment or complaint, still allows for relief from CCW standards. So there is a factual pattern, at least as far as the as-applied challenge goes, where defendant could have applied for relief during the time that his charge was pending.
And this is left to the pure discretion of the judge that you apply in front of? Is that this, I mean, how does that work? How do you apply for relief?
You apply for relief under 2923.14. You submit an application that lists your disqualifying factor. 29, I don't know the exact statute, but 2923.125, the licensing statute, says that if you're granted relief as to your whole firearm rights, you would be granted relief as to your CCW. You would be able to apply. My understanding of how it works is you submit an application under 2923.14. You're listing your disqualifying factor that limits your firearm rights is, I have this pending indictment, I have this pending complaint, and the court can, subject to its discretion, choose to grant that relief. And that's not, also not a factor here. Not that I think it could have been, because as we would attempt to submit, there was a specific order on that negligent assault to not carry firearms during the pendency of that case. Thank you.
Thank you. Ms. Nelson, you have 3 minutes.
Regarding the concealed carry regulation in this case, although concealed carry is considered to be presumptively constitutional, we still have to consider the individual restriction on its face, whether or not, just like the age restriction that I argued before this court. I know the case hasn't come out yet, but we still have to justify the particular restriction. Just like age, it's an objective determination, but it's also arbitrary. Where is the historical support for the restriction based on age?
Would you agree, though, that Ohio could ban all concealed carry as long as people could open carry, and that would be constitutional under the Second Amendment? Do you agree with that?
I don't agree
Okay.
with that.
Tell me
Because
why.
I think open carry was an option in Bruin, and that case involved a concealed carry restriction. The concealed carry restriction was, and I apologize if I'm misspeaking or misremembering Bruin, I don't intend to mislead the court, but my understanding of Bruin was the concealed carry law that was at issue restricted, it was subjective and wasn't, the subjective aspect of it was problematic. And I believe people in New York could open carry, even though it was limited based on, sorry, I think I'm talking myself out of my position, but there's the fact that people can open carry, though, doesn't make all concealed carry laws constitutional, is what I'm getting at.
That's what you're saying.
Yes.
And that's where I get hung up, because it looks like there are historical analogs to concealed carry bans as long as you can open carry. And what you seem to be arguing about, these carve-outs, to me just seem to sound in a equal protection argument.
I remember this discussion from
Right,
the age
right.
question, and I respect that observation.
Tell me why I'm wrong.
Because Bruin doesn't tell us that we need to go down the equal protection frame.
Well,
legal
that
theory.
wasn't even an issue, though, in Bruin.
But
Wasn't
Bruin also, I think, opened the conversation to question concealed carry restrictions. It doesn't say that they're affirmatively constitutional. It doesn't say that they're affirmatively unconstitutional. It just says that we're allowed to ask these questions and have the historical analysis question. We're allowed to ask that question with respect to concealed carry restrictions. I know that there are hurdles because of, the language that they're presumptively constitutional, but that doesn't mean we cabin them to a completely different area of law. Not yet, anyway, until the United States Supreme Court decides to pivot once again on the Second Amendment question with respect to concealed carry. I think concealed carry laws still get Bruin treatment.
I'll let you wrap up.
Yes,
You're almost out of time.
To circle back to the first assignment of error, the pat down upon approach question that was raised by this court, I think is inconsistent with Henson. And on that basis alone, we still need to, that Mr. Hall should not have been subject. He couldn't have been subject to a pat down upon approach. And the reasonableness about suspicion of criminal activity as it relates to him, being in the specific spot where police thought the shots came from. One fact I want to call attention to is the time. In Harrison, it was 30 to 60 seconds, police arrival time. This case concerns 2 minutes. Henson concerned somewhere around the ballpark of 5 minutes. So there's a time component that makes the officer's arrival on scene, observation of a person, more suspicious or less suspicious. And because we have a lot of people at the scene, a time component that's relevant here, the 2 minutes to get to the scene, and some inconsistencies about where the shots are coming from. Yes, police were directed to the spot, but 2 minutes have gone by. So who were the original actors? And with that, I'd ask this court respectfully to reverse. Thank you.
Thank you. Thank you all for your arguments this morning. The case is now submitted, and we will issue a timely decision. Have a good rest of your day. All right, the next case is State v. Yoder. Ms. Gleiser, would you like to reserve some rebuttal time?
Yes, Your Honor, 3 minutes, please.
All right, whenever you're ready.
Thank you. May it please the court, new justices, State of Ohio. I'd like to focus my discussion this morning on the first assignment of error in my brief, the pre-indictment delay, which I think is the most interesting issue that I've raised in this appeal. And where I'd like to start with that is why Mr. Yoder's case is different from the cases that are cited by the State of Ohio. The cases that are cited by the State of Ohio, State versus Bourne, State versus Jones, and a lot of the cases in this context, if you look at pre-indictment delay and rape cases specifically, are cases where you find these backlogs in processing the DNA kits or the rape kits, these new integrity units that are being utilized where they are running DNA for the first time after it's been sitting in some lab for 15 years, say, 17 years. And so in those cases, you have new evidence. And that's what's important for this case, because there is absolutely zero new evidence with respect to James Yoder. And so why I think this is unconstitutional is that the state had all the evidence that they needed to prosecute a rape case, and they sat on it for 3 years and decided to do nothing.
Wasn't one of the pieces of evidence the state didn't have the witness's testimony because she was in rehab for the injury and she was in fear?
So based on my review of the transcripts and the testimony, while the state argued that, the detective made it pretty clear that she was reluctant to move forward with the prosecution in the beginning. And that was one of the reasons why she said she did not move forward. But if you think about that, the State of Ohio prosecutes cases all the time when they don't have the cooperation or a witness is reluctant. Like, for example, in the domestic violence context or assault, when the police are investigating that sort of case, they prosecute the case regardless of whether the prosecuting witness is reluctant or not. And then when the case is set for trial, if the prosecuting witness does not show because they do not wish to move forward with the case is then dismissed, right? Dismissed for warrant of prosecution, and they have 1 year to bring the case if the victim or the witness is interested in moving forward. So I think if you look at it in that context for a misdemeanor, but then you have a rape, of something that's much more serious in nature, and they decide to sit on it until conveniently the day that he's acquitted in another case, I think it's unconstitutional, and I think he suffered actual prejudice in his defense in this case.
But, counsel, you argue in the insufficiency of the evidence portion that the witness's testimony in and of itself was insufficient. And here, that witness's testimony was the only thing that could have supported the prosecution. Is that correct?
Yeah, well, I mean, certainly they have. You're never going to see in a review of these cases where you just have the testimony of someone alone coming in later and saying, I was raped 4 years ago, for example, without any corroborating evidence, right? Can you repeat your question?
Sure, and let me rephrase it. The prosecution can determine when they think they have enough evidence to get a conviction. Is that correct?
The prosecution, yes,
So
certainly.
in the cases that you cite, like domestic violence, if the prosecution, despite not having the witness testimony, determines that they've got video from a camera or neighbors hearing screams, if they determine they can proceed without that testimony, they have the right to do that.
They do.
And if they don't have enough evidence to support continuing, they can wait and determine if they can develop enough evidence. Is that right?
The prosecution certainly on behalf of the state of Ohio, can determine when they feel they have sufficient evidence for a prosecution.
And in this case, there's nothing else that supports the prosecution other than the witness's testimony, is that right?
The witness's testimony as well as the DNA evidence, certainly.
So what is the actual prejudice from your perspective? What is the actual prejudice to your defendant?
So, Judge, I mean, the case law is pretty clear that they have a higher standard than what I would argue as a defense attorney. I mean, I think anytime that you have a delay in prosecution, there's always going to be prejudice, right? But the case laws, the standard for review is much higher than that. You
It's
have to-
actual prejudice.
the actual prejudice.
Yeah.
And so, in looking at the case law, one of the things that a court can consider is whether or not the evidence that's missing could bolster the defense. So the defense here, Mr. Fowler's defense at trial, was that this either did not happen or it did not happen in the manner in which AP said it did. They essentially are attacking her credibility for a number of reasons. And why I think this is important is because they chose not to prosecute the case right away, you don't have the body cams. And I get it, body cams are not always available in cases. But in this case, it would have been particularly important because in one of those cams, she identifies another suspect as being one of the people who had raped her. You have a group of people who are highly intoxicated, okay? It would have shown her demeanor and state of mind at the time when she's reporting this to first responders. You would have witness statements in the body cam from the other two individuals, at least two individuals that we know were present on the body cam, according to the firefighter that testified at trial.
Isn't it kind of retrospective speculation to say that would have helped? Like, maybe in a best-case scenario, that would have helped?
So,
I mean, we just don't know.
So, Judge, I understand the case law talks a lot about mere speculation, not enough. When I think about mere speculation, I think about those cases where, in the cases cited by the state, you come in 20 years later with this new DNA sample that's finally been processed, and the defense attorney is arguing at that point, well, how do we know if we had witnesses at the time? How do we know if there was evidence to support our consensual sex defense? How do we know if there was any DNA at the scene? It's, in those cases, I would argue it's always actual prejudice, but the defense attorneys are stuck with speculating in those cases, and that's why the case law, in my opinion, is bad, because they're stuck with speculation because of the amount of time that's passed in the prosecution. But here, I mean, I think it's more than mere speculation. For example, they did not process the crime scene at all. If they had taken photographs, if they had visited the crime scene, if they had documented any of the physical evidence, we may not be in a position to argue that there was prejudice, because we would, for example, know whether or not there was a rope present. I mean, the defense presented an expert at trial who testified that she had no injuries consistent with being drugged by a rope or tied by a rope to a tree. So I think knowing whether or not there was a rope, whether or not it could have been tested for DNA, is more than speculation, because we know these physical items existed there at the crime scene.
But we don't, when you talk about witnesses, we don't know what any witness might have said that witnesses went missing, I guess, but we don't know what they would have said, right?
I would agree, Your Honor. Again, because these individuals were homeless and transient in nature, it would have been impossible with the length of time that passed for the defense to be able to properly investigate them, their statements, their recollection of events, because of the time that had passed. And when you give deference to the trial court's acceptance of fact, you have to look on whether it was based on competent evidence. I think the trial court got it right. She based her decision on the actual prejudice based on the testimony of Mr. Ficker from the Public Defender's Office, who was an investigator and attempted to do a bunch of this.
And don't you think, though, the heightened standard of actual prejudice, I mean, it's necessary in order to, I mean, the state does have a statute of limitations that they have to bring the case in. So if we're going to toss a case based on pre-indictment delay, don't you think that this heightened standard is pretty necessary before we throw a case out? I mean, we can't just speculate. These people might have said something. This might have shown something, right?
I would agree,
We
Judge.
tossing cases all the time.
Yeah, I would point out the language in Bourne cited by the state. The Supreme Court rejected the state's argument in that case that a defendant must establish what the testimony was and why it was exculpatory. And said that specific evidence of testimony that would attack credibility is enough. So I think
We don't have that here, though, do we?
the evidence that I'm arguing that the defense no longer had access to would have been used to attack her credibility. Because remember, this is not a conviction for one rape. We have a series of events with a very intoxicated individual who other people at the scene should have been able to determine whether or not she was assaulted for the felonious assault count, tied to a tree and raped versus raped in the tent. And I think it specifically goes to her credibility in this case.
But counsel, even if there was prejudice, you have the other component of whether or not the delay was justified. Is that right?
That's correct?
And was any portion of this 31-month delay justified?
I argue it's not. And several of the cases that I cited in the brief, State versus Mackey, the woman in that case was charged after she testified against her husband at trial. The state wasn't satisfied, and based on that, they indicted her after her testimony, and the court said that was not a justifiable delay. They had waited all these years to prosecute, similar to what happened with James and the fact that he was indicted the same day he was acquitted on another case. And then State versus Dixon, same situation where after his parole was revoked and he was returned to prison, they decided to indict, and the court in that case said that was not justifiable delay. I would argue the same thing here. They had all the evidence that they needed in the beginning of the case, and they only waited until that other case was tossed.
But they didn't have the witness testimony, is that right? Because she didn't want to cooperate and she was hospitalized.
She was hospitalized for a brief period of time, and I don't know that the testimony was necessarily clear that she did not wish to move forward. But again, all of the time in cases, the state moves forward with the case and prosecutes. They don't necessarily base their decision to prosecute on whether someone says they wish to move forward or not. And
You said, but in a rape case? I mean, I understand in other types of cases, but this is a rape accusation.
Right. I
It
mean,
seems different.
yeah, I agree, Judge. It's a serious case. According to what I remember from the transcripts, the detective testified that she met with her, she wanted to prosecute, she received the DNA kit like a day or two later, and she calls her back, and she's reluctant to move forward, and she just drops the case. So she never tries to follow up. She does no investigation. She doesn't try to determine whether or not she's changed her mind. I can understand why someone might in one phone call say they're not interested in moving forward, but I think the police still have an obligation to do their due diligence.
You're at your time if you want to reserve some rebuttal time.
Yeah, I do, Your Honor. Thank you.
Thanks. You'll have 3 minutes.
Morning, may it please the court. Scott Heenan on behalf of the state. This court recently readdressed and actually clarified the standard of review for this court, or that this court uses in these types of cases. That was just actually 5 weeks ago in Hahaj, I guess I'm saying that right. But it's a mixed question of law and fact, that you will look at the facts that the trial court found and apply them to the law. And when you do that here, I think you're first going to find that actual prejudice legally was not shown here. Actual prejudice isn't what could have been, it's what would have been. And as the Supreme Court had said in State versus Bourne, it needs to be something very specific.
This is virtually impossible to show, too.
I don't think it's virtually impossible. And if you look at the cases that the Supreme Court cited in Bourne, the one that's in there is an example of prejudice with State versus Luck, which is where the Supreme Court first started to develop the test that we use today. And there, it was shown that the only witness who could testify as to the defendant's self-defense claim had died. And that was the only witness that this defendant had that could support her self-defense claim. In that case, the Supreme Court found there was actual prejudice. Now, when you look at the Bourne case, and you look at the facts there, it's actually quite similar to what happened here. Now, there was a delay there because of the rape kit. It took a while to get the rape kit done. But ultimately, even after that was done, there was a delay between when they got the kit tested and when they finally got the report and indicted the man. It was a 12-year delay. During that time, phone calls between the victim and the defendant were lost. The case file had been lost. The investigator had died. The bar where things started had closed, and most importantly, and most on point here, with the inability, apparently, because of clothes or otherwise, to view the camp where this happened, the house where the rape happened in Bourne had been demolished. These are things that the Supreme Court has looked at and said, that's not actual prejudice. You have to be able to show more than just stuff was lost. You have to be able to show that it would minimize or eliminate the impact of the state's evidence and bolster the defense.
So in the case that you cited with the self-defense,
Mhm.
where the witness died, did they know what that witness would have said? Or were they speculating what the witness would have
They
said?
were not speculating. I don't remember the exact wording that was in the decision, but there was not speculation. There was enough specificity to, even if there was some speculation involved in that, it wasn't just this would really be nice to have. This is stuff that would have been nice for the state to have, too. I would have loved to have had the body-worn camera footage. Maybe there was something in there that would have been helpful. If there was a rope, that would have been great evidence to also have, to see if it had DNA evidence on it.
And what efforts did the state make to gather that evidence at the time? I know there was a reach out to the witness or the victim in 2019. What else was done?
There were multiple attempts to reach out to the victim, and when the police got there, it had been a few hours after the rapes had occurred because she had to find somewhere to plug in and charge her phone to call 911. So it took her a while before she was even able to summon help. So at that point, things could have obviously changed. Beyond that, I really, at least for the motion to dismiss that was filed, I can't tell you, because they didn't call those witnesses, and it was their burden to show that there was the actual prejudice, and they didn't do that. But even if they had shown that there was actual prejudice here, when you look at why we, the state, did not go forward, it was because the victim, at first, was severely injured, and second, severely afraid. And that was something that the trial court did find. It was her injuries, suffered significant injuries in this case. It required her to go to the hospital, to go to a nursing home to recover. And the victim was in fear of the defendant and retaliation and did not want to come forward.
How long was she in recovery for her injuries? 'Cause of the 31-month, any idea how much of that time was recovery?
I do not recall the answer to that. I can
Thank you.
find it for you. And
No, sorry, that
it's in
was-
the transcripts. But ultimately, at the end of the day, what Mr. Yoder is asking this court to do is not only to overrule the Ohio Supreme Court, but also the U.S. Supreme Court that it is relied upon. And when you look at the decision that the Ohio Supreme Court is relied on, it's Lovasco. I'm going to read one quote from that I really think sums this up, and that is, rather than deviating from the elementary standards of fair play and decency, the prosecutor abides by them when he refuses to seek indictments until he is completely satisfied that should he prosecute, he will be able to promptly to establish guilt beyond a reasonable doubt. Penalizing prosecutors who defer action for these reasons would subordinate the goal of orderly expedition to that of mere speed. I agree. If we had indicted immediately, that would have been very quick. That would have been very speedy. We didn't have the victim, and we needed the victim to go forward in this case. And it wasn't that we were hiding the victim. It wasn't that we were keeping the victim away. The victim was simply afraid. And when you look at the rationale behind the cases that have led us to where we are today with the standards that we have, there's plenty of information in Lovasco where they explain how requiring what Mr. Yoder is asking for would be prejudicial, not just to the state, not just to the courts, but also to defendants. And that's why the Supreme Court has said, you have to be able to show actual prejudice. And even after that, there has to be, an unjustifiable delay. And in this case, the delay was absolutely justified. Beyond that, the other issue that was raised here, and I know that it was not brought up by opposing counsel this morning, that I found to be actually somewhat interesting, was the competency question that was raised in this case. And as I know this court knows, that competency is a fluid thing. It's not a static, like an NGRI is a static. You either were or were not guilty by reason of insanity. Competency, you can go in and out of competency throughout the course of a trial. And in this case, the competency became an issue between the verdict and sentencing when he started having religious delusions of grandeur, wanted everyone to refer to him as King John, apparently thought at one point he was Jesus Christ. Obviously, at that point, those were all signs that he was incompetent. But when you look at what happened during the trial, as the trial court explained, the trial court had a front row seat throughout all of his proceedings, is that up until that stuff started happening, nobody thought he was incompetent. Maybe problematic. I mean, he made some outbursts and did some unusual things, but those were things that were not attributed to his competency. It did not show that he was unable to assist in his own defense.
Was he off his medication throughout the entire trial, though? Isn't that what the record showed?
I believe it does show that, but as the doctor explained, she had no idea how quickly Mr. Yoder would decompensate. And, I mean, at that point, we're completely speculating, and we're also saying that throughout his trial, and it wasn't a short trial, throughout all these proceedings, the court never noticed it, the prosecutor never noticed it. Most importantly, his multiple defense attorneys didn't notice it either.
Yeah,
When
I
you
said,
say-
oh, go ahead.
When you say the doctor explained, it was in the sentencing competency evaluation. Neither of those doctors, the medication doctor or the psychologist, testified they didn't give an expert opinion that he was actually incompetent during trial.
No, they did not. It was all about, because again, his competency is a fluid state, and they did not go back and say retrospectively that, oh, well, he's incompetent today, so he must have been incompetent a week, a month, a year ago.
Can that be done?
In theory, I think it could be, but it certainly wasn't done here.
I mean, they'd have to present that person, they'd have to put that evidence on at that competency hearing for the purpose of sentencing to kind of have that retrospective expert opinion, right?
There would have to have been something. And when you look at the report here, he clearly was not competent during that window between the verdict and when he was sentenced. And he was restored and then was appropriately sentenced.
So
But-
he was being very problematic throughout the trial. In
Sure.
fact, I think he had to watch part of the proceedings outside of the courtroom, right?
Yes.
And you're saying, and I think that's what the record bears out, that no one, not the judge, not defense counsel, thought to send him for a competency evaluation during this time?
No, just because you're a difficult defendant does not mean you're incompetent to stand trial. And as Judge Lubers noted when she was ruling on this, Mr. Yoder was perfectly cordial until something didn't go his way. And then he became a problem. And that it was a very targeted problem. That's, I don't like what just happened, so I'm going to have an outburst. But when things were going okay, he was perfectly fine. That's not competent. That's maybe, that's a disruptive defendant. And if every disruptive defendant is incompetent, we're going to have a lot of incompetent defendants. So unless the court has any other questions about the case, I would submit on the briefs and ask that you affirm.
All right.
Thank you.
Thanks.
Thank you.
Thank you.
Also, I think this was both your first day, so welcome to the court.
Thank
Thank
you.
you, Mr. Eaton.
Ms. Glazer, you have 3 minutes.
Thank you, Judge. So, while there was no expert opinion regarding his competency, we did have the testimony of Dr. Fernandez. She said that if he was off of his medication for 3 weeks, he would have reverted to incompetency.
Well,
So-
so when was that testimony?
That-
That wasn't
that-
in the sentencing competency, that was in the medication, the forced medication. Is that right, or?
No, Judge, I don't want to misstate the accuracy of what I, take this with a grain of salt, because I didn't review the transcripts this morning. However, I do believe that her testimony was elicited once the defendant filed a motion to have him evaluated for competency prior to sentencing. So, once they had that testimony, then they subpoenaed the records from the Justice Center and determined that he had not been, in fact, taking his medication for the entire trial. And
Could they have gotten an opinion from this doctor about whether she believed he was competent during the trial? Because it seems like that's a missing piece here.
I think they certainly could have tried.
Yeah.
I didn't see that they had done that.
Yeah.
I think they attempted to do their due diligence with respect to calling her as a witness and obtaining the records. So I think they did do that, but they did not elicit an expert opinion. And so we go through these great efforts to involve a defendant in the process, right? So if you disrupt the trial, like Mr. Yoder did at one point, he's still allowed to communicate remotely because he has a right to assist in his own defense. It's a constitutional right, it's very important. Why it's important in this case, more so than others, is because of the pre-indictment delay. Mr. Yoder would have been the only person who would have actually been to the scene, who would have interacted with this individual, who would have known the other characters that were present that night. And if he's not able to assist his counsel because he's not competent, then that's a problem. And, the difficulty with the attorneys is that you have a client, at least from the transcript, they understood he was being medicated in the jail. So it was only after they hear this testimony that they then uncover that he's not being medicated, that he's not competent, and they had believed all along during the trial that this bizarre behavior that he was exhibiting was just a result of not wanting to participate in the process. It was only after, and that's why it's newly discovered evidence, and that's why the motion for the new trial should have been granted.
Even though, I guess you're saying his lawyers thought he was being medicated, I'm just really surprised that nobody suggested that he be evaluated for competency at all during those proceedings. And I, the judge relied pretty heavily on that the lawyers didn't even indicate that they thought he was incompetent. So they were able to work with him.
Right. Yeah, and I asked myself that same question when I began drafting the brief, is just whose obligation is it? And it's a difficult call, but I think the right is important. And so for those reasons, I would ask the court to reverse.
All right.
Thank you.
All right, thank you.
Thank you.
Thank you both for your arguments this morning. The case is submitted, and we will issue a timely decision. Have a good rest of your day.
Thank you.
Thank you.
All rise.